Hey guys, welcome to the think tank. I am just setting up. Not on time. I'm just getting this figured. So I'm going to put that down there. How you doing? How are we doing? I need to set this up a little bit. Okay. Give me 2 seconds here as I'm figuring this out the best I can.
Thank you. We're now on the record. This is the state of Idaho versus Bryan Kohberger. Got an echo there. So. Case number CR 2922-2805. Got that adjusted properly? Okay, great. Couple of things I just want to share. Number one, I apologize for the delay. We were supposed to start at 1 o'clock. The hearing that started at 9:30 went a little long, but it was important. You're probably wondering why it was sealed compared to this part of the hearing, and that is because we were dealing with the procedure of the grand jury, the procedures of the grand jury, and there were a lot of details, and the grand jury is secret. So that's why it's sealed, and whether you like it or not, it's baked into our United States Constitution and the Idaho Constitution. So there's a reason for that. I advised camera people not to turn on the cameras until I was on the record, and they turn off when the record is off. I just want to remind you, you just heard Matt talk to you about not having your phones, your laptops to film anything, to record anything. That would be a violation of the rules. And we will take away your laptop or your phone. Some of these rules have been violated in some of our hearings, and I have an obligation to put a stop to that. And I'm sure you're probably interested in this. I haven't put a decision out yet, but what I'm going to do is take control of the cameras in the courtroom. I'm not going to ban cameras in the courtroom, but I need to have more control over what the cameras are doing and what media or people who are not media are doing with the filming. I know I can only control so much, and that's why I continue to urge people to be patient and have some dignity and some restraint. And some of that I've heard or seen has been disappointing. Just so you know, yesterday I issued an order addressing IgG DNA, and there's going to be an order for in-camera review that I'm going to go through. In-camera does not mean anything about a camera. That just means I look at the information before I can share it with the defense. You see, what else did I want to kind of share with everybody? I think that's about it. So we're here now on the defense motion to dismiss indictment on grounds of error in grand jury instructions or in the alternative remand for preliminary hearing. So Mr. Logston, I believe, is going to present the argument. Thank you.
Thank you, Your Honor. Well, as Your Honor is aware, I wrote a lengthy brief or two on the subject of where we're supposed to be legally with our grand juries and where we actually are. And as Your Honor let me know this morning, probably not going to change your mind because the Idaho Supreme Court has, I think the court thinks, gone the other way. So I guess I would accept that kind of ruling as long as the court agrees with everything else that happens. But
I don't know about that.
assuming that you don't, let's, I guess, just kind of walk through the simple steps here. So at issue in this particular case is Idaho Code 19-1107. And the infamous language in it that says that grand jury ought to find indictments and all evidence before them taken together, unexplained or contradicted, would in their judgment warrant a conviction by a trial. And the first question that a court has to ask is, what does that mean? And you start with the plain language, which we argue. What warrants a finding or a conviction by a trial jury is beyond a reasonable doubt. And it meant that back in 1887, when the territory took all of these statutes, almost entirely from the state of California, and it means it today. And then we also pointed out that the great state of California, when they had these on their books from back in the 50s, had already a case in 1962 where they said that it's clearly something more than probable cause, but they weren't too specific about exactly what it meant. And the state has pointed out that if you look at really old dictionaries, it looks like the word warrant means what you might think it does. Old-timey folks, as it does to us, that if it warrants doing something, it means that it would permit doing something. So the plain language seems to support what we're saying. And the biggest problem that I have then is just that obviously everyone in the country disagrees with me from sea to shining sea. And so I'm now put in the position of trying to explain why that occurred and why in the year of our Lord 2023, we are suddenly finding out that that's not quite how things are supposed to be. Why did we forget that we passed all these laws? And I don't have a great answer for that, other than I think the only time I ever heard about field codes before I was looking into this was like a really short moment in a class that I took back in law school. So, I mean, it's somewhat famously kind of the first attempt to codify the law of the day. It takes place in New York and spreads across the country back in 1850. And I think what I read in the tea leaves from the New York decisions in the later California decisions is that there was pushback at some of the things that the field code is trying to do. And one of the things the field code very openly said it was trying to do was fix the grand jury system. Because the grand jury system was believed to be essentially broken. For a lot of the same reasons we don't seem to like grand juries very much today. We essentially believe that grand juries were hard to control. Grand juries would essentially always favor whatever it is they were told and would always indict the accused. And so as a system to protect people, it didn't seem very protective. And they pointed out in the field code, if you go back and read it, that essentially the secrecy aspect of the grand jury is both its most powerful sword and its kind of its worst aspect at the same time. Because you just don't know what you're going to get out of it. And so they create a bunch of statutes that start to rein in what grand juries can and can't do. And they create some scenarios under which grand juries can be reviewed. And they, in the New York, they call it their Court of Appeals, it's their Supreme Court, says, even though we have these statutes that say we should only set aside these indictments into these particular moments.
Is everything coming through loud and clear for you guys? I did get approved for being part of the pool, so I hope that's what we're doing right now.
Clearly, there's got to be some sort of a due process protection. If you're going to pass a bunch of statutes that rein in a grand jury, and if you can show that somebody's not following those to the prejudice of the accused, then that's going to work for dismissal as well. And that doesn't seem to be very controversial. We see similar language in that Gaspar case that we talked about in the state of Idaho, which I think dates to like 1913 or something along those lines. But at the same time, while the state of New York is trying to figure out ways to not have to abide by the language of what would warrant conviction by essentially saying, if you can tell the grand jury that is their burden, but you can also tell them the probable cause thing, as long as they hear both of it, it doesn't really matter. And then the state of Idaho says, well, that's not even what that means, without any additional explanation for what they're talking about. And California apparently just kind of forgets about it until sometime after they've already passed a law in the 40s that says you can only dismiss a grand jury indictment if you can show that there wasn't probable cause. That kind of moots the whole situation that they've obviously fixed it by statute. Our situation is such that we have this thing on the books, and the only group that seems to really dislike it is our Supreme Court, who keep having these opinions where they're like, please, prosecutors, stop telling people it's beyond reasonable doubt. This happens in the early 1900s, and it continues until the 80s, when they finally say, look, we passed a rule. I hope it's clear now. Stop saying that your burden is beyond reasonable doubt. Well, as the court knows, the way that those rules get created is a bunch of people that get invited to parties, unlike me, in the legal community go and are selected to sit in a room and decide what those rules should say. And there's quite a bit of the time it seems like the Supreme Court.
I'm trying to figure out if I'm doing all of this properly. So everything's coming through loud and clear for you guys?
Court will later have an opinion and go, this is weird, why is this one in our rules? And so to simply say that, well, because the Supreme Court wrote it, that's their opinion on the matter isn't quite accurate. But clearly the Edmonton court was behind that as a concept. At the same time, nobody was arguing with them about it. Nobody argued about it, the issue, until just now. Well, that's not quite accurate. Obviously, Mr. Ornosco raised this in a few district court cases up in Green County. But nobody's really been digging into this or raising it until this time. So when the court says, look, the Supreme Court's already got a rule on this, Supreme Court's already ruled on it, it's just not true. They have never ruled that probable cause is the basis because there was an argument about it and they said, no, you're wrong, it's probable cause. That hasn't occurred. They ruled a lot of things, but that's not one of the ones. And the fact that they adopted a rule that says something that they believed doesn't necessarily set in stone what the law is, or for that matter, what the Constitution has to say about it. So the big issue, I think, at least my favorite issue here, was can the Idaho Supreme Court override the legislature and lower the burden of proof for the
He is so super, super creepy. I watch him move around and he moves his eyes and then he kind of moves his head a little bit and then he darts them away. He's just so super creepy.
And that was a tricky one because we don't really have a case that just comes out and says that the burden, or for that matter, I guess I don't know, we got this all kind of mixed up when we were doing the arguing. So the burden of proof, I think we decided was actually who has to show something, and then it was the standard of proof is the amount that has to be shown. But everybody confuses it all the time, and I'm confusing it right now as well. But I'll call it the standard of proof just to be less confusing. In any case, the standard of proof is that something that the judiciary has power over? In other words, is that simply a procedural rule, or is it a substantive rule of law that courts can't mess around with? And we argued, it cannot be that if the Supreme Court woke up tomorrow.
So this is my first time doing this. I applied at the court to the courthouse to be able to be part of the pool. For this part of it anyways. So the way I'm understanding it is I can go in there now and there's usually like one pool that's one station that's doing it all and people can stream off that. So I hope I'm doing this right. I just checked with JS for Justice and how she was doing it. So I hope I'm doing this okay. But in the meantime, I'm going to take small breaks because I just don't want to get myself in trouble because I figure this out for sure.
And declared that the standard of proof in our cases was something beyond reasonable doubt in trial cases, that we would also say, oh, well, that's what the courts get to do. Because if you read those cases, what they talk about is that is a right, a due process right, essentially, of the accused that is set by the Constitution, right? That's what In re Winship is. It set the standard via the Constitution, locking in the standard of proof that's required for a conviction. And so when we talk about these standards of proof, it is true, obviously, that if you look through the case law, you'll see courts setting a standard of proof for their own evidentiary rules. But you don't see it in many other places. What you see them doing instead is having somebody come in and say, well, the legislature set this standard of proof, but we think you should make it higher or lower based on, and almost nobody ever says lower is always higher. And we're always arguing that the Constitution clearly must set it in at some higher point to protect people, and then the courts lean in and say, well, we don't see any particular reason why the legislature messed this up, or if you're in the United States Supreme Court, occasionally you say, well, we do think that this is goofy and we're going to raise it. Okay? I couldn't find a case where the Supreme Court or anybody else leaned in and said, we think that the legislature is being a little too protective of its people here, and we're going to move down the standard of proof for the government in this particular case, or one party versus the other. Typically, in this country, we try to protect the accused, and we believe that those protections are given to us via the Constitution and via these concepts of due process that come to us with common law, which is where this gets so messy, because the common law would tell you that it's probable cause, and it's some guy named Field in New York who's telling you that it should be something else. Well, we could get into all of that, but it would be, I think, more philosophical than anything else, because the state of Idaho didn't do it that way.
Yeah, that's a great question. I mean, I would think he'd be freaked out because I know I would, but does this guy actually get freaked out? I don't know. I really don't know. So if you see me kind of moving stuff around, popping in and popping out while we're watching this stream, I apologize. I'm just trying to get it where I think they probably want this. This is my first time being part of the pool, so I'm trying to figure it out.
The state of Idaho, as a territory, adopts a bunch of codes out of California, a code that they've already looked at, a code that they've already said, these words clearly mean something more than probable cause. This is what you're adopting. If you come and get it, the state of Idaho goes and gets it and adopts it. So that's what the state of Idaho is adopting. I obviously recognize that the founders that wrote the Constitution did not appear to recognize what was already on the books in this regard. However, just because they didn't recognize that doesn't mean it's not still part and parcel of what was thought to be true by a large portion of the citizenry of Idaho, who are the actual ones who ratified the document. The only thing we know is that from 1890 to Edmondson, the Supreme Court of Idaho was repeatedly admonishing prosecutors to stop using a beyond a reasonable doubt standard for a grand jury. And that, it seems to me, is pointing to this concept. I think we're going to talk about common practice. The common practice looks to have been that everybody thought that the standard for the grand jury was beyond a reasonable doubt. And I don't think this is like worthy of the grave nightmares that I've been reading about. Obviously, in each one of those cases, the prosecutor was able to pull it off. And little wonder, I mean, it's still a grand jury proceeding. It's still just the prosecutor in a room with 16 citizens, 12 of which have to agree. They get control over basically everything that's being put on. I mean, the guardrails being put in, hey, let's use admissible evidence. Hey, let's not pull in hearsay witnesses. That kind of thing is not going to somehow make this impossible and make it so that it can't possibly work. What it's intended to do
years, maybe 100 years. It was different. It was different there for a period of time, but after Edmondson, I thought that it was pretty much settled. Now I understand the argument between substantive and procedural, and that's a legitimate argument, but I'm not sure it's fair to just say, well, they were given the wrong instructions if everybody's using that instruction throughout the state.
Well, Your Honor, if that were true, then I'm not really sure what I'm doing with my life, because I've spent much of it arguing that things that everyone in the state is doing are wrong.
True.
And occasionally, rarely, but occasionally, somebody says, no, that guy's right, and my client walks out of prison. So
well, that's fine. You can make an argument that something should change, but are you telling me that other places in the state are giving a different instruction that it should be beyond a reasonable doubt?
What I'm telling you, Court, is that it appears that up until 1980, that was true. And so the Supreme Court enters its rule, sort of has this ruling that talks about that, but nobody's arguing about it because they don't have access to the internet. and nobody has a copy of the field code or what California was up to.
Well, Justin Weislein argued about it in a dissent in Edmondson.
And we thank him for it, although.
Okay.
If you
can't
go
say
back-
that there hasn't been an argument about it.
Well. No. If you go back and you read what Justice Weislein did, Justice Weislein didn't know about the field code. He knew it came out of California. He knew that it meant something different.
I think it's attached on the dissent.
That's
Some of that.
No,
Oh,
California.
those are earlier. Oh, that's the earlier session.
He has the California code, and he has the stuff on the territories. That's what he's got. But he doesn't know. If you read the field code, which apparently nobody did, except, Justice Field in California, if you read it, it literally tells you what it's trying to do. It spells it right out. And you can find it for free on Google Books, which is where I got it. I don't have a copy. I'm not even sure where you find it, but except for Google Books, you can find this thing, and they had a whole preamble to how they're trying to save the concept of the grand jury. They want it to be better than what it is. They understand people are concerned.
Look at him. He's just, can you imagine running into this creep at night? Are you kidding me? It's people like that whack job. So I've been watching his posture. Like, look at how he's all hunched over. He's been like this way for the most part. And his eyes, he moves his eyes and then he's just creepy. He's just creepy. Yipes. Okay, let's see if we can get past this, because I know we can. Oh my God. Look at that. Look what we're missing. Thank God. He's still talking. What? Whoa. Make sure she's not getting...
Setting the standard of proof, even though there is a statute that says otherwise.
Holy crap, is this guy long-winded? Unreal.
They can't do that. That didn't become something that, they did it, but the court is in a position to consider whether or not they could do it. The court can tell the Idaho Supreme Court this rule isn't constitutional. Courts can do that. We consider bail issues. We consider bail on appeal, things like that. Statute versus procedural rights. Those things occur. And the lower court can look at that like anybody else can. Who's in the right? Is it the legislature or is it the court? So I think the court can decide all these things. But if the court's going to say it can't, I hope you'll at least write a 32-page order in which you explain how right I am about everything except. Thank you.
Thank you. I appreciate the argument. I think it's really creative. And I appreciate the journey back through history. I think it is an important factor in determining what the law is and why the law was established the way it was. But even you, okay, and I've heard this, but even in your brief, and this is your quote, okay, that the whole of modern jurisprudence on the issue is against it, as well as the least one founding father of this state. So I get it. I mean, what it comes down to me is that I am constrained by what I believe is settled law in Idaho. I may be wrong, but this is certainly an issue that you would have to bring up with a higher court, like the Idaho Supreme Court, and I look forward to getting that from your perspective settled in Idaho. We'll see. There's the rule, of course, which is we've talked about But this argument really is fighting against some case law too. You may say that it's all dicta. I mean, that's debatable, I suppose. But the Idaho criminal rules, specifically Rule 6.5A.
Hey there, Maxie. Didn't you get my message? I thought maybe you'd seen that. You said you were gonna do something. I was like, I'm streaming. So I'm still trying to figure this out. Please, so rude. I'm still trying to figure out if I'm doing this correctly. Like I'm not, I sure hope so. So I'm taking lots of breaks. So rude. Ugh. So creepy, but I think you're probably right. Like, oh, I don't even know what to say about him. Just creep vibes.
Expressly states that probable cause is the standard, not beyond a reasonable doubt, and for a grand jury's indictment.
What you got there, Lizzie?
And I think I have 3 or 4 recent, because this argument has been circulating in the state. I think I've had 3 or 4 district judge decisions denying the motion and the argument. So I am going to deny that argument. I think the argument is good, but can't go that far. Not today. I'll give you a written decision. I can't guarantee it's going to be 32 pages. It might be longer. It might be shorter. So we'll see. But it's always enjoyable to have an argument with you, Mr. Longston. So I think that's all we. But this argument really is fighting against some case law too. You may say that it's all dicta. I mean, that's debatable, I suppose. But the Idaho criminal rules, specifically Rule 6.5A, expressly states that probable cause is the standard, not beyond a reasonable doubt, and for a grand jury's indictment. And I think I have 3 or 4 recent, because this argument has been circulating in the state. I think I've had 3 or 4 district judge decisions denying the motion and the argument. So I am going to deny that. Is the standard, not beyond a reasonable doubt, and for a grand jury's indictment. And I think I have 3 or 4 recent, because this argument has been circulating in the state. I think I've had 3 or 4 district judge decisions denying the motion and the argument. So I am going to deny that argument. I think the argument is good, but I can't go that far. Not today. I'll give you a written decision. I can't guarantee it's going to be 32 pages. It might be longer. It might be shorter. So we'll see. But it's always enjoyable to have an argument with you, Mr. Longston. So I think that's all we have.
Denied. Not today, sir. So I don't know. Like I've been saying, you guys, I really hope that I'm doing that right. I have to look into it a little bit more. But like I was saying earlier, I did send away to get approval to be, get approval from the courthouse so I can be part of the pool And it looks to me like that's going to probably be, who are we just listening to? Court TV. So I'll do some more looking and see how that works. But yeah, not today, sir. So Mexi, you had been saying something about another possible update. So I'll catch up with you really quick on the other side. Thanks, everybody. If you haven't subscribed, please do. And the rest of you, I totally appreciate you. Okay, have a great evening, and I'll see you guys in the next one. Bye.